Hello, sir. Good evening.
Yeah, good evening.
So, with your permission, shall we start the webinar, sir?
Sure, please go ahead.
Yes. Gopika, go with intro.
Yes, ma'am. Good evening, dear participants and our esteemed guests present here today. I am truly honored to welcome you all to this insightful webinar on litigation versus alternative dispute resolution, or ADR, that is being organized by Wino Legal. We are gathered today at the discussion of litigation and ADR. Now, litigation involves formal court processes, often resulting in lengthy and costly outcomes. In contrast, ADR methods like mediation and arbitration focus on negotiation and collaboration, providing quicker and more cost effective resolutions. We will explore the advantages and disadvantages of each approach in today's legal landscape. We are honored to have a diverse group of participants with us this evening, ranging from law students, academicians, legal professionals, advocates, and members of the judiciary. Your presence here today is a testament to the growing interest and urgency in understanding the similarities and dissimilarities between litigation and alternative dispute resolution. It is thus with immense pleasure and deep respect that we want to introduce our honorable guest for the evening. So I will be passing over the virtual mic to my co-host, Shreyashi.
It is with great pleasure and profound respect that I welcome you to today's webinar featuring the distinguished Sri Dr. Aditya Sondhi Sir, a senior advocate practicing before the Supreme Court of India and the High Court of Karnataka. We are truly honored to have him with us today as he embodies the spirit of legal excellence and intellectual rigor. Sri Dr. Aditya Sondhi Sir was born in Bangalore on July 18, 1975, and is a first generation lawyer who has made significant strides in the legal profession. His journey exemplifies the transformative power of education and dedication. He he graduated from the National Law School of India University, where he now serves as a visiting faculty member, teaching subjects such as constitutional law, arbitration, professional ethics, and a pioneering course on courts and national security. Dr. Sondhi Sir's commitment to education is evident in his efforts to inspire the next generation of legal minds. In 2014, Sir was appointed as a senior advocate, a designation that reflects his exceptional skills and contributions to the field of law. At just 38 years old, he became one of the youngest individuals in India to receive this honor. His legal acumen was further recognized during his tenure as Additional Advocate General for Karnataka from April 2016 to April 2018, where he played a crucial role in various landmark cases. He has also been appointed as amicus curiae in several matters of public importance, showcasing his unwavering commitment to justice and the rule of law. Dr. Aditya Sondhi Sir holds a PhD in political science from Mysore University and has made significant contributions to legal scholarship, including a chapter on elections in the Oxford Handbook of the Indian Constitution. His work has enriched academic discourse and provided valuable insights into the functioning of our democracy. Additionally, he has authored two non-fiction books with Penguin India, further establishing his reputation as a thought leader in the legal community. Beyond his legal expertise, Sir is a passionate advocate for philanthropy and education. He founded the General K.S. Timaya Memorial Lectures, fostering intellectual discourse and honoring a great leader's legacy. His commitment to social causes is evident in his advisory role at a school of journalism, where he emphasizes the importance of truth, nonviolence, and love. Sir's journey is a testament to hard work, integrity, and a commitment to making a positive difference in society. On behalf of Wino Legal, we once again extend our heartfelt gratitude and a very warm welcome to Honorable Sri Dr. Aditya Sondhi Sir. We are deeply honored to have you with us today, sir. With utmost respect and anticipation, we now invite you to take the virtual dais and enlighten us with your invaluable insights. The floor is graciously yours, sir.
Much for that introduction, and thank you, Vino, for this invitation. Thank you, Purnima, my colleague at the bar in the Supreme Court, for having reached out. I'm here to speak to you about litigation versus ADR. Ideally, the word versus should not have been in the title, and it should have been litigation and ADR as complementary facets of Indian justice delivery. But the way things have played out, it seems to have become an either or option because of a series of reasons that I will cover in the course of my talk this evening. Access to justice is part of the guarantee under Article 21. And when we speak of access to justice, we imagine access in terms of cost, access in terms of time, and access in terms of formality. And unless on all three fronts, the processes of justice are such that enable common citizens to approach the court, access remains lopsided. Access to justice is not access to big ticket lawyers by parties who have deep pockets. That is a subset of access. But real access is access to justice which has a social justice implication. And that's where litigation comes in. If you speak of litigation, litigation is the bedrock of access to justice in a sense, because it enables adversarial decision making through the process of court. So looked at in this context, one expected alternative dispute resolution to enhance access to justice. It is intended, at least in its object, to be cost effective, time effective, and less formal, and to be swift in terms of execution of its results. But what we have found in practice is that ADR is anything but that. And I don't want to use ADR as a broad term. Let's first start with arbitration. I'll come to the other element of mediation / conciliation / negotiation a little later. And at a starting point, we must be very clear that arbitration remains adversarial. Arbitration itself is not mediation or non-binding in that sense. It is mediation that is more in the realm of non-binding negotiation under the supervision or the guidance of a professional mediator, leading up to an agreed settlement, which then becomes enforceable once there is a contract or a settlement between the parties. But arbitration, of course, is meant to be free of the trappings of court in terms of formality, supposed to be more cost effective, and supposed to be more efficient in terms of time. But otherwise, an award of an arbitrator is made after adjudication of a dispute and has the deemed effect of a decree of a court. But how far has arbitration been a substitute in this sense and enabled access to justice? First and foremost, let us be clear that one cannot simply wish that arbitration replaces litigation, because arbitration has its own inherent limitations in terms of jurisdiction. Not all disputes are arbitrable. And if at the top of my head I give you 3 areas of law which are non-arbitrable, you'll realize what I mean. One is criminal law. The entire gamut of criminal litigation that clogs the Indian legal system is not amenable to arbitration. Of course, you have some plea bargaining, etc., in the realm of criminal law, which can sometimes take some load off the system. But it's not arbitration. Matrimonial disputes are not arbitrable, right? Because there is a certain public law, public policy element involved in the grant of a divorce. And therefore, those matters remain in the realm of the family courts. And as all of you know very well, matrimonial cases are one of the main force multipliers of dockets in Indian litigation. Just recently in the Supreme Court, there was a matter that was being heard before Justice Nagratna's bench, and she indicated that one matrimonial dispute typically in the experience of the bench of the Supreme Court, means between 7 to 9 cases between the parties. So between the same two parties, that is the husband and the wife, one matrimonial dispute can mean 7 to 9 cases, which go from the divorce itself to maintenance, to custody, to criminal cases, to 498A, to property disputes, etc., etc. So this entire chunk of disputes is not arbitrable. And then insolvency. A big part of commercial litigation is insolvency law. And insolvency or winding up or liquidation, whatever you may call it, is deemed to have a public law element to it and is therefore not confined to arbitration and is mandatorily to be determined before the company law tribunals that are set up for that purpose, or earlier before the High Court in exercise of its company jurisdiction. And there are many other exceptions, which I won't go into right now, but just from this illustration of 3 major categories of substantive disputes that are non-arbitrable, you can see that litigation remains a far bigger set in comparison to arbitration. And if arbitration cannot take care of many of these disputes, then it is really a non-starter when it comes to the question of whether it has been able to, sieve out the dockets from the caseload that the Indian legal system is burdened with. There's some disturbance. Please put your yeah. Now, one can see the logic behind it. You can hardly contemplate criminal matters that involve societal morality, that have a larger impact on society. Just today we heard about a well-known politician being convicted for rape. You don't want cases like those to be tucked away in arbitration, and I can understand that. But the point that you need to understand is that with all of these limitations, arbitration remains a very small subset of the Indian litigation paradigm. And it really therefore is confined to contractual commercial disputes. And what one has found in practice is that even those contractual commercial disputes don't always find themselves going to arbitration. And that is because of a multitude of reasons. Either parties don't have a clause in the contract, and as you know, without an arbitration agreement, there can be no arbitration forced on a party. And unfortunately, the credibility of the arbitration system is such that rather than people opting into arbitration, people are opting out. I think that is a slap on the face of India's efforts with arbitration, that we have really not become that arbitration hub that we hoped we would. We tried to be a substitute to Singapore. You had the London Court of International Arbitration, the LCIA, set up offices in India only to pack up and leave. So in terms of the objectives of being an institutional arbitration hub, we're a far cry. And one would want arbitration in India to be a popular choice where parties that don't have a contract, look, many disputes are non-contractual. A dispute that you have, let us say a joint family dispute, a dispute in a partnership without a contract, without an arbitration clause, and a boundary dispute with a neighbor. These are even possibly tortious disputes where there is no contract in place, or the contract is silent as regards arbitration, would still contemplate arbitration, where parties come together and say, yes, we will now opt into arbitration. Under Section 7 of the Arbitration Act, even an oral agreement for arbitration, a reference to an arbitration clause inter se in pleadings in court, or a post-dispute arbitration can give rise to arbitral proceedings. So one should have actually reached a stage today where arbitration has such credibility and force that parties would say, yes, there's no contract, there is a dispute in a joint family, let us opt in for arbitration, have an arbitrator appointed, and the dispute resolved outside court. But we have in fact reached a stage today, friends, where parties are opting out of arbitration. Either in international contracts, parties do not want India to be the seat of arbitration, or you do not want Indian law to apply, or as you have seen recently, the example with the Delhi government and even with the Karnataka government, the public works departments have said future contracts will not have arbitration clauses. That's a huge statement. It is a systemic recognition of the fact that when it comes to disputes involving the state, arbitration has been found to be wanting. Of course, you may say that states have been at the receiving ends of arbitration, therefore they find it may be better to have a general dispute resolution clause that forces a contractor to go to court, pay court fees, etc. But that's not the only reason. Unsatisfactory arbitral awards, exorbitant claims being awarded, other ethical challenges in the course of arbitration have actually meant that people have gone back to the drawing board and said, we don't want to engage with arbitration in India. And this is not just the public sector. I know in my interactions with general counsels in corporations that even corporates have begun to rethink arbitration, to say it's not worth it because it is really an additional layer of litigation. What was supposed to be alternative dispute resolution as an alternative to court has become an additional dispute resolution mechanism, because you go to arbitration and then you come back to court. Many times you go to court pre-arbitration. And as the Delhi Metro case shows, that in a curative petition, an award came to be set aside. I don't have time to go into the nitty-gritty of that judgment, except to say that even in the corporate private sector, precedents such as Delhi Metro send out a signal that nothing is final. The whole intent behind arbitration was meant to be the award is final with a limited scrutiny in court. But if an award of a tribunal can be disturbed in a curative petition, please note, after going through 2 rounds in the High Court, 34, 37, 1 SLP under Article 136, a review petition against an SLP, and then a curative petition, which is the rarest of rare instances where the Supreme Court can set aside an order passed in an SLP, you find that an award has been set aside. So if you take these aspects in mind, you find that arbitration has actually hardly been a cost-effective substitute. It takes longer because the number of rounds you go through has a +1. It's the normal duration in court +1. And yes, I'll grant that with amendments made, fast-track arbitration, special arbitral benches, in some states, in some cases, you find arbitration matters being decided a little more expeditiously. But generally speaking, the arbitration is one entire chunk of litigation outside court, only to return to court and to go through the entire rigmarole. With that comes the cost. The cost is actually exponentially higher. People always thought that arbitration would mean you're saving on court fees. In some states, you pay as much as 5-6% of the claim. So you save on the claim and you go for arbitration. But what you save in terms of court fees, you end up paying in terms of arbitral costs, lawyers' fees, and infrastructure costs. For those of you who have been involved in big ticket commercial arbitrations, you will know the cost factor is enormous. Flights for arbitrators, flights for counsel, 5-star accommodation, 5-star conference rooms for hearings, big arbitral fees, and because there is no court fees, claims get magnified. So a dispute that is X becomes 10X. And because a counterclaim does not attract its own court fees, it may attract, of course, an arbitral fee, especially if it's institutional arbitration. But a counterclaim surfaces, and therefore X, 10X with the counterclaim 20X, and but naturally then the fee payable to the arbitrators and the fee payable to the council also increases. So where is the cost saving at all? And what this also suggests is that arbitration essentially in India has now come to be hogged by large scale commercial litigation. That is hardly access to justice, friends. I mean, that is an option, a luxury option for those who can afford it and who then probably don't mind the costs that come alongside in court. But those who thought arbitration would mean smaller disputes, family disputes, as I said, disputes with neighbors, other civil matters, property disputes, which could be reconciled through 3 or 4 sittings before an arbitrator, finality where parties accept awards because that's the spirit of arbitration. I'm afraid that's hardly what arbitration in India has come to be. So it remains litigation versus arbitration. And for those of you who are considering arbitration from a career perspective, this has a very important lesson. This is not just a theoretical exercise in ADR versus litigation, etc. It has very serious practical implications. One is it shows you the larger picture, that if you want to really be in the system of justice delivery and creating access to justice, then arbitration is a very, very small part of it. It will not give you the satisfaction of doing criminal law, criminal trials, etc., etc. The other, and perhaps the more important lesson is the skill set. So often I hear from young lawyers and students saying, we don't want to get into court, we don't want to be in litigation, but we want to do arbitration. And I wonder to myself, how are you going to be an arbitration lawyer, or for that matter, an arbitrator, if you do not have the basic skill set of litigation? This is actually where litigation and arbitration overlap. It's not versus, but it's litigation and arbitration. In an arbitration, your drafting skills, your application of substantive law, your cross-examination of witnesses, your appreciation of evidence, your arguments on law, and ultimately the writing of an award are all substantive litigation skills. Yes, I will grant that the Arbitration Act relaxes the application of CPC and the Evidence Act. But that's not to say it excludes it completely. It's not that arbitrators can disregard the principles of evidence law. They may be not bound by CPC procedurally. They may devise their own procedure, but nonetheless, evidence is led. If you're not equipped with the skill set of cross-examining witnesses, how are you going to conduct an arbitration where there is complex oral evidence required? Added with the fact that I pointed out earlier, that in an arbitration, there is court right from the point of appointment of an arbitrator to interim measures, which are pre-arbitration, to appeals from Section 17 orders of the tribunal. Many times writs are filed in court against procedural orders of arbitrators. And then the entire post-award litigation, which is the Section 34 challenges, appeals against those orders, and ultimately appeals or specially petitions to the Supreme Court. And I'm only speaking about domestic arbitration. International arbitration has its own complexity in terms of enforcement and the court interference there, and the adjudication of what contracts are void or not. Now, all of this is intrinsically linked with court. Can you then say, I will be an arbitration lawyer who only does arbitration, meaning only appears in arbitral proceedings, but does not appear in the court part of arbitration? Yes, whoever's raised a hand, you'll have to wait for later, please. Questions at the end. So all of this is intrinsically linked with litigation. And unless that experience and those skills are available to you. You can hardly say that I'm going to be a pure arbitration lawyer. So that from a career perspective is also something that one must keep in mind. I know that one is now moving towards a regime where we're speaking about an exclusive arbitral bar. I can see the merit in that, which is to say that court lawyers like myself cannot say that I will not be able to go for an arbitration matter on a Monday morning because I'm required to be in the Supreme Court. That's not good enough, because professional arbitrators would have set their schedule and said, we are going to hear a case 5 days in the week, Monday to Friday, close evidence, close final arguments, and write the award within a couple of months. That is actually where arbitration does well, where good arbitrators and good counsel are able to cooperate and say, yes, this is the itinerary, and we're going to go through with it. And that's where a professional arbitration bar enables lawyers to say, yes, we're available. If it's Monday morning, it's Monday morning. But please remember, these are also hearings in private. These are not public hearings. So those of you who have the pleasure of sitting in court, following cases in court, following cases online, cannot do that in arbitration. If you want to follow a contested arbitration that is going on, you can't log in as an interloper. These are private hearings, and unless a tribunal permits somebody to sit in, they are not on the record in that sense. And also, now there is an ongoing conversation about whether arbitral awards should be reported. Judgments of courts are reported. Arbitral awards are not reported, at least in India. There are jurisdictions where awards are treated as reported. They are made public. They're made public because it's transparency. You don't get to read awards of arbitrators. Supposing I want an award in a dispute, you are not going to be able to find it out. There is no public repository of awards. And therefore, the publishing of awards adds to transparency and also makes it, in a sense, a precedent, if you will, to be cited in other arbitrations, if not in court. But these elements of litigation are also missing in an arbitration. And those of you who enjoy the process of court, enjoy the public advocacy, are going to be missing these facets in an arbitration. Of course, you have the luxury of arbitration being conducted in private. As I said many times, that is a luxury sort of facility to have. But that said, one of the strengths of arbitration, and this is the strength of good arbitration in India, and I can tell you this from experience, is that when you're before good arbitrators, where the time schedule is tightly fixed, and you have multiple witnesses to cross-examine, one finds that arbitration is actually a fantastic substitute for court. And I had done an arbitration involving a matter of demonetization, a rather complex matter of force majeure, demonetization, etc., where one had to examine not only the prime witnesses of both sides, but also economists and experts on certain facets of the impact of demonetization on public policy, its impact on the implementation of certain contracts. I can't go into those details. But we needed, therefore, to complete cross-examination of 3 witnesses over a very, very bulky record in about, I think we had 4 to 5 days allotted. But this was the charm of it, that one could start at 10 a.m. and go through 5 p.m., 5 days back to back, and go through exhaustive cross-examination of 3 witnesses, experts, have their evidence recorded, and then go into the final arguments. Now, this luxury you will never get in court. 5 days of cross-examination, 10 to 5, I'm speaking about with, if you exclude the breaks, you're talking, let us say, ballpark 5 hours of sitting a day into 5 years, speaking about 25 concentrated hours on evidence in one case. Please tell me how much time that would take for you to find in court, in a civil court or a commercial court. if a commercial dispute required 25 hours of oral evidence, where would you get that time? You may get at the most 1 hour a day when the court is free, depending on its board. Okay, 2 hours even. You're still looking at somewhere between 12 to 25 days of sitting. And as you know, in courts, unless there is a direction from the Supreme Court or the High Court, you're not going to get day-to-day hearings. And that therefore means a dispute lingering on for years, minus, the great facility of being able to cross-examine witnesses in the spur of the moment when you're fresh. As you know, as counsels, if you have to come back and cross-examine a witness after 2 months, you've lost that preparation. So that is one of the strengths of arbitration, and I've experienced that in cases like this and another dispute involving the genetic makeup of certain cotton wool types of cotton, which involved scientific evidence, etc. And these are in fact, I would say the strengths of arbitration. But unfortunately, this remains confined to a certain bubble of big ticket corporate disputes and has not found its way into the larger realm of dispute resolution in India. And therefore, it remains a small subset and hardly fits into the larger litigation access to justice landscape in our country. Now, with this said about arbitration, I want to spend time talking to you about mediation as well, friends, because ADR cannot just be equated with arbitration. In fact, it has fallen short, as I have tried to show you. But mediation, in my opinion, stands on a different footing. Mediation, I have a lot more time for. And I think this is where there is still a ray of hope and a great scope in the Indian legal system. Because mediation is not confined by the restrictions that arbitration had. I told you that there are limitations on disputes that can be arbitrated, using the example of matrimonial cases. But using the same example, let me say the greatest need for mediation is in matrimonial disputes. And there is no embargo on settlement of matrimonial disputes. I told you one matrimonial case can mean 7 to 9 cases clogging the system. Not just clogging the system, breaking relationships, putting children, parents, spouses through the punishment of the process, many times putting them in jail, putting children through the trauma and mental health issues of seeing their parents in court, children being dragged to court, sometimes as young as 3 years, 5 years, to ascertain their view. Is your mother brainwashing you? Is your father brainwashing you? Who do you want to be with? Sometimes in camera, sometimes not. But as you know, this is never fun. It's never fun for a litigant. Just imagine the plight of a child being dragged to court. And this is exactly where mediation fits in. That for 7, 9, 10 cases, and look at multiple levels, 7 cases in the trial court can mean another 7 appeals, writs, SLPs. If you do the math, one dispute between a couple can mean sometimes multiple appeals, 20 litigations. And a mediator, a good mediator, and one sees this often in matrimonial cases, is able to resolve all of these disputes off the record through a conciliatory process and arrive at a conclusion where this entire chunk of litigation is taken out of the system. So you're doing a great favor, firstly, to the system by pulling out X number of cases, reducing the load, and more importantly, giving an acceptable solution to the parties. This is where litigation versus mediation comes in. Litigation never gives you that win-win. Litigation is win-loss, win-lose. One party wins and one loses. Of course, there are gray areas in court where sometimes neither party wins, but it's adversarial. But in mediation, you walk away then with solutions not only that are legalistic or financial, but they also have the ability to repair relationships. There are matrimonial disputes where parties have fought bitterly and gotten back together. And if I extend this to family disputes, partition disputes, partnership disputes, business disputes, mediation has a terrific ability to repair relationships, to enable parties to continue to work together, or at least otherwise walk away without being bruised financially, bruised by time. I am doing cases in the Supreme Court which have begun in 1962. 63 years of litigation, 3 generations, not able to settle. Who wins? I don't know. And this is where, friends, mediation becomes a very, very important force multiplier when it comes to the challenges that the court system faces today. Even in arbitration, mediation is often used. In fact, it is the mandate of an arbitrator under the Act to encourage parties to settle and resolve. And through methods of med-arb and arb-med, arbitrators are able to structurally build in mediation. One is a pre-award mediation. The other is arb-med, which is to say to reach a stage where evidence has been led, arguments have been made, and just before the tribunal goes into making of the award, tells the parties, okay, now I will give you, or we will give you 2 months to try and settle, come back to us, because you know the relevant relative strengths and weaknesses. Evidence has come, arguments have come, you know what the broad inclination of the tribunal is. That can give parties a reality check. And in the US, you will find that many instances of corporations moving away from litigation towards arbitration, in-house arbitration. I was reading somewhere that Toyota has in fact built in a clause which says that the arbitration will be binding on it. But if the other party loses, they can go to court. That enhances credibility. And it enables parties to negotiate. In the introduction, you had used negotiation, mediation, arbitration interchangeably, but they are not. When parties can negotiate pending an arbitral award, they are looking at a mirror. They know their strengths and weaknesses. They know that an award is going to come. And as I said, the exorbitant cost factor. A litigation leads to an arbitration into 5 when it comes to costs. All of that can be factored in. And let me tell you, friends, therefore, there is a lot of room in the mediation space. When I said skill set, maybe in arbitration, there are many skills which overlap with litigation, but I firmly believe that mediation can stand alone. The skill set that a good mediator has, even as a counsel, your role as a negotiator requires you actually to forget your litigation avatar. You can't be combative. You can't be frictional all the time. You actually have to come into a very different space of reconciliation. Of course, a good mediator is required to take stock of the relative merits of the case. But that said, and when you work with good mediators, you find they have such ingenious techniques enabling parties to come back frequently, letting the bad blood go. There are mediators I've seen who are so patient. Patience is not a skill we people have in court, at least I don't. But good mediators are able to sit back and let parties vent, let the bad, especially in matrimonial family disputes, many times 90% is ego, hurt, pain, 10% is the law. And to let that ego drain itself, let the bad blood drain itself, and bring parties together is a very fine service one does to the community. And it's a very different set. And I would hope that young lawyers are able to pursue these courses, these specialized courses, and find those skill sets as mediators. As a counsel, I will tell you, the satisfaction when parties settle a dispute is something different. It's very special. And as a counsel, we have a duty to encourage clients many times. As seniors, of course, we don't have direct clients anymore. But I'm speaking of the time when I did have direct clients. The cases where we could encourage settlements, speak to a colleague at the bar, pick up the phone and say, why don't we settle this? And try and shake hands and move on. Actually gives you great satisfaction. Unfortunately, these instances are not often, because many times clients are combative, or one lawyer doesn't want to settle, or whatever. There can be multiple reasons, but it gives you great satisfaction. And if you're able to develop those skills and see your role as a good mediator, be it in a formal sense as a mediator or even as a counsel, negotiating, encouraging settlements, you have a great deal to do. Of course, I told you there are structural differences. A mediation is non-binding, it's off the record, and if you don't have a settlement, you go back to court. But that said, a good mediator is also able to draw up agreements of settlement which give you finality. Lok adalats, that is an important part of ADR, where judges act as mediators, conciliators, and settle disputes, insurance disputes, motor vehicle claims, number of small money claims which don't really need to remain in court, which you can settle. You can tell a party, all right, even if you think you're legally in the right, if the claim is 1 lakh and the insurance company has to pay it and be done with it. And good clients accept it. And it's not just these cases. Many of you will be aware, the Ayodhya case was referred to mediation. Perhaps one of the most contested and delicate disputes that the Supreme Court had to deal with was referred to mediation because there was hope that there could be settlement. Of course, because of the complexity of not just the matter, but the complexity of, all the attributes of that case, the case could not be settled. But the fact is, there is room to settle through mediation, even cases like those. I'll grant that, pure questions of law, constitutional disputes, etc., cannot easily be settled. And wherever the state is a party and state is the biggest litigant, it's not easy to mediate because officers of the state are reluctant to settle. They are worried that there will be some inquiry into their work. Some Lokayukta will pick it up or vigilance will pick it up. So there are too many red tape issues, and therefore getting states to resolve cases is difficult. But still, there is room, just as good counsel, to be able to advise settlements. And that was my role as the additional AG also for the state, to say not everything needs to go to court and be fought out. Many times, just an affidavit of undertaking or a compliance solves the matter. All of these contempt cases which are pending in court, 90% of them deal with delayed compliance. And if you're able to show compliance in reasonable time, the case is closed. That is also a form of conciliation. Everything does not have to be adversarial, right? Even the recent dispute regarding the passing of bills by the governor, of course, it required a judgment of the court. It has now gone into a presidential reference. But there is equally room many times for advice, good advice to a governor saying, just do the right thing under the constitution. Put out the fight, put out the storm. And that's where, friends, I think mediation is a very, very important and a growing area, I think, in law. When it comes to the Commercial Courts Act, Section 18 of CPC, they have mandated mediation and conciliation in commercial disputes, in civil disputes. The courts have an onus to encourage it. Pre-litigation mediation. All of this has an important role to play. I return to the point as I close now, with which I began, which is access to justice. And if justice can be achieved through a conciliatory process, why court? Why 6 rounds, 10 rounds of litigation? Why a lifetime of litigation? If you're able to sit across the table, be reasonable, give up something, take something, mend relationships and move on. That is also access to justice. And we as lawyers therefore have to see ADR in that light, to say that it is creating that environment for parties ultimately to go away with the satisfaction that they have got something from court. And my last point is that even through all of this litigation that I mentioned, Getting a decree, getting an award is one thing on paper. Enforcing it is something else. Post decree enforcement, execution, contempt takes its own sweet time. Those disputes become a fresh round of litigation, and parties have to go back sometimes to the Supreme Court to get the fruits of their decrees. And that is hardly access to justice. Justice ultimately tangible, should be tangible. That a party takes something away, not just Pyrrhic moral victories or paper victories. And the sweet part of mediation is good mediation is you get that in hand. A good settlement, a good mediation settlement enables parties to actually take something home from that. And that is, friends, access to justice. So with that, I'll stop and take some questions from you now. Yes, please. Purnima, any questions? I can't hear you.
Sir, can I ask a question?
Yes, yes, please.
Sir, is the settlement through mediation bound the parties to comply with the settlement, or and the party which does not comply with the settlement, is there any provision to punish that party?
See, that depends on the type of mediation. Under the Arbitration and Conciliation Act, the entire chapter on conciliation has a formal set of sections which deal with the binding effect of conciliation agreements. So if one submits to that and has a conciliation agreement drawn up within the meaning of the Arbitration Act, it becomes enforceable. And you have a right then to enforce that. But you see, supposing it is a completely off the record settlement between two parties, you just sit across a table, draw up a settlement agreement. Then if there is a breach, I'm afraid there's no choice but for you then to go back to court and enforce it. But the important thing there also is that the settlement becomes the proof of the settlement, the proof of the agreement or the understanding. And you have crossed that entire stage of the dispute and reached an agreement, which then becomes enforceable. Of course, there are many complexities to that. Also, people challenge settlements. I've seen Lok Adalat awards being challenged, saying there was fraud, coercion, etc., etc. But I won't use those examples. But if it is a binding conciliation, it can be enforced through the mechanism of the Arbitration Act.
Thank you, sir. One more question, sir.
Yes.
The award passed in Lok Adalat, can it be challenged?
You see, a Lok Adalat, again, unless there is fraud that vitiates the settlement or some coercion, the award is binding.
Award is binding. We can challenge it in High Court, or where it should be challenged.
You see, that depends on where the Lok Adalat has taken place and whose award it is.
If it was in district court, then
You see, then in that case, that award would many times be recorded as a compromise.
yes, sir.
If
Yes,
it is
sir.
recorded as a
Yes, sir.
compromise under Order 23, you have to go back to the executing court and no one else. Whereas if it is an award, as I gave you the example of insurance
No,
disputes.
if the party doesn't comply with the order of Lok Adalat, only in that case situation I am asking, sir.
Then the question of challenging the award does not arise. Then you have to enforce it.
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
That you see that many times, sir, it also depends where an award is recorded as a compromise.
Right, sir. Right, sir.
Yes.
Right. Thank you, sir.
Yes, please.
So few questions from the organization so that it enhances the participants also, knowledge of participants also.
Yes.
So could you please elaborate on how litigation skills like cross-examination and evidence handling enhance an arbitration lawyer's effectiveness?
That's the question.
Yes, sir.
So see, I just gave you the example of an arbitration I did over 5 days with multiple witnesses before a tribunal of 3 retired Supreme Court justices. Now, this is, for all practical purposes, nothing but a cross-examination that happens in court. You may be sitting in a hotel not wearing your robes but wearing a suit, but otherwise the principles of evidence law, admissibility of questions, objections to questions, and the eliciting of answers from the witnesses are all core skills that you gather through court and through litigation. I don't think those are skills you suddenly develop sitting in an arbitration. I don't think so. If you do, good for you. But I feel that good cross-examination is a skill that you develop through a trial practice, through an exposure to witnesses. And therefore, in an arbitration also, look, the Arbitration Act has a provision which says some disputes can be decided on the basis of documents only. And if parties agree and there is no oral evidence to be led, it's fine. But in many cases, building disputes, property disputes, etc., that go to arbitration, you have multiple witnesses being deposed. And therefore, for all practical purposes, the skills of oral arguments, of cross-examination, etc., remain the same as litigation. Yes, please.
Sir,
Yes.
I have a question that you told that it is a tangible. I mean, the award is tangible over this. And mediation must be neutral, impartial, independent, professional, and ethical. Whether the mediator must not have the knowledge of the mindset of above the things along with the knowledge of law.
Must not have the mindset of?
Above all the things, I mean, ethical, professional, impartial, neutral.
Of course.
Because it is not a mechanical process. You told that once it is done, the mediator is very happy. And he has some content in the mind that he has done something. And it is a win-win situation for both the parties.
Yes.
So whether he must have such things, sir. Along with this,
the credibility of the entire ADR process depends on the ethical system and the ethical practices of the people that are involved in it.
yes, sir.
In fact, one of the main challenges to arbitration in India is the sharp ethical practices. I can't go into it right now. There's no doubt that arbitrators who have a conflict of interest, etc., must straight away disclose it. And as you know, under the Arbitration Act,
Yes,
there
sir.
are disqualifications that apply when there is a certain type of conflict, and some conflicts can be relaxed by the consent of the parties. And that's equally true of a mediator. If a mediator is not ethical or is prejudiced or has some interest in the dispute, then that mediator is a disgrace to the system. And that settlement then is also a lopsided settlement, because the settlement may never satisfy the parties. If a party discovers an interest of the mediator 10 साल बाद या 5 साल बाद आपको पता चलेगा कि ये mediator एक side के वकील रह चुके हैं, you will want to reopen that settlement. So there's no doubt, though a mediator is not a judge or an arbitrator deciding a dispute, there's no doubt that a mediator must have equally high ethical standards. And in fact, under the Act, the requirements of a conciliator formally appointed
Yes, sir.
are those. You must have an ethical standard, and you must also have a strong skill set as a mediator. I'm saying this. People think being a mediator is easy. It's not. And the senior lawyers who are attached to the mediation centers in the high courts and the Supreme Court, I have admiration for many of them, because they are able, as I said, they are able to step away from the baggage of court. They don't think just as lawyers. They have developed so many human skills, negotiation skills, which we lawyers don't have. Many times judges also don't have it, because you're programmed to decide. You're programmed to decide a dispute. You're not programmed to think outside the box, think of many, many other aspects that go into mediation. So yes.
I feel that it's not a mechanical process. One must imbibe the parties. Thereafter, he inculcate the things into their minds, sir.
Correct, correct.
Sir, thank you. Thank you very much, sir.
Hello, sir. Good evening, sir.
Yes, please.
Sir, as if you are talking about the skill set of the lawyer should be while coming to the from litigation to the ADR. So, what would be your tips for the upcoming lawyers regarding the drafting or being for the developing of the skill set?
Skill set regarding?
Sir, for the upcoming new lawyers or law students to develop that skill set.
No, skill set for what aspect did you say? I missed that. Arbitration, you're saying?
Yes, sir. For the ADR or for even to the litigation.
See, sir, you need to be able to identify what are the core aspects of litigation that overlap with arbitration, number one. And those remain drafting, application of law, research, oral evidence, and arguments. Those skill sets, according to me, remain the same. And therefore, your training must be such that it meets the thresholds of both. Then you will be competent not only in the arbitration, you will be competent in all the court hearings and proceedings that take place around the arbitration, as I told you, appointment, interim measures, challenges, etc., etc. But then please remember that there are some facets to arbitration which are unique to arbitration, which may not apply in court, and one needs to focus on those also. And there are many, many aspects in arbitration which are being developed in the matter of the manner in which examination of witnesses takes place. Sometimes the examination of multiple witnesses at one go. And these are sophisticated techniques that only arbitration follows, which court does not. And that requires you then to have the work ethic of an arbitrator. So if you're interested in arbitration, then it becomes a value addition to have the core litigation skills and add on these elements that are unique to arbitration. That then prepares you fully for being an ADR lawyer. As I said, the third element is the soft skills that go with the mediation. So if you're involved, then you may be involved as a lawyer in a negotiation. The arbitrator may ask you as a lawyer to sit across the table with the opposing lawyer and the parties and try and negotiate a dispute. That requires completely different skills. The skills of a negotiator are quite different, and there are specialized courses which are available for negotiation. I would encourage you to take those, because those fit in nicely with ADR. Yes.
Thank you, sir. Thank you.
With your permission,
Sir,
can
as-
we question answer session, sir?
Yes, please.
I want to ask the question.
Yes.
Sir, as you stated that India has not become the arbitration hub. So according to you, what key reforms are needed for India to truly become a preferred arbitration hub?
Look, there are multiple, some of them are to do with the law itself, which is that the extent of court intervention needs to be looked at once over. I've always said you can't treat arbitral awards as beyond judicial review, because that is in itself not healthy for the system. Because many times awards are vitiated either because of corruption or vitiated simply because they lay down the wrong law.
Yes,
And
sir.
there is no reason that parties must be bound by that. That's also not justice. So there must certainly be at least one recourse against an award. But that said, the way we are structured, we have a section 34 that goes to the district court, unless a high court has original jurisdiction like Delhi. Then you have an appeal against that, and then an SLP. Now, I feel you can cut out one layer completely and substitute the courts, and I've said this publicly in some conferences, that substitute the role of the court with specialized arbitration tribunals. Just as you have the National Company Law Tribunal, which is comprised both judges and expert members, you have that in the National Green Tribunal, etc. You can have specialized tribunals that have both, either judges or lawyers who have a strong arbitration experience and possibly even experts. Construction disputes have their own expertise. You can have engineers or contractors and have tribunals of that sort,
Yes,
and
sir.
have that as a one-stop shop. So one section 34 go to the tribunal, and then the only avenue is the Supreme Court. I think that will, to a large extent, cut out the uncertainty and the time that goes with court, and that tribunal can exercise all powers surrounding arbitration, right from appointment to interim measures to challenges. The other, of course, I think, is a credibility crisis. And we need, therefore, more good arbitrators. We need more practitioners in arbitration. We need a better work ethic in arbitration. And as I said, we need to also encourage less glamorous disputes for arbitration. Arbitration need not always be 5-star, 7-star. Even small disputes are the sorts that should go to arbitration. That is a credibility thing.
Yes.
And that requires a better approach from all the actors that are involved, the players that are involved in arbitration. It needs better scholarship. You need more people writing about arbitration, better discourse in law schools about arbitration, where this is inculcated from a start. Yes.
Thank you, sir.
Good evening,
Yes.
sir.
Yeah. Maybe one or two more questions so we can
Yes, sir.
wrap up in about 10 minutes. Yes, yes, please.
Sir, despite the numerous advantages of ADR, such as cost effectiveness and time efficiency, why do people still opt for litigation in courts?
You see, as I told you, there are multiple reasons. There are lots of disputes that are not arbitrable. So there's no one answer. Firstly, the dispute must be arbitrable. Then secondly is the experience with arbitration. As I said, though it's supposed to be cost effective, it has proved to be anything but that. So there are actually corporations where general counsels have said our experience with arbitration has been such that it is open-ended, it is expensive, it's time-consuming. We're probably better going to court. And sometimes, of course, as I said, with governments, it could be convenience, which is to say that if there's no arbitration, you may actually discourage parties from going to court. A contractor may not go to court if they are required to put down 5-7% of their claim. They may actually come around for a settlement rather than going to court at all. So there could be multiple reasons that weigh with parties.
Okay, sir.
Yeah.
Thank you so much.
Yes, please. Any more questions? There's somebody who has a hand up, I think. No, I think we're done.
So I think we can conclude with your permission, sir.
Sure.
As we come to the close of this deeply insightful webinar, it is my privilege to extend our heartfelt gratitude to Honorable Dr. Aditya Sondi sir for sharing his profound knowledge and candid reflections on litigation, arbitration, mediation, and alternative dispute resolution in India. Sir, your comprehensive analysis gave us a realistic and nuanced understanding of how arbitration, while designed to be effective and cost-effective, remains limited in scope. Your clear explanation that certain critical areas like criminal law, matrimonial disputes, and insolvency matters are not arbitrable reminded us of the enduring importance of litigation in our legal system. That observation that arbitration, far from replacing courts, has become an additional layer, often expensive and complex, was truly eye-opening, sir. We deeply appreciate your emphasis that arbitration is inseparable from courts, sir, and that young lawyers must build solid foundations in litigation skills such as cross-examination, evidence handling, and pursuance of oral advocacy to succeed in arbitration. Your real-world examples, including fast-paced cross-examination in demonetization arbitration, provided valuable context to this demanded practice, sir. Equally important was your strong advocacy for mediation, a field requiring a unique skill set centered on patience, empathy, and emotional intelligence. Your insights into mediation's transformative potential, especially in family and matrimonial disputes, and its ability to preserve relationships while resolving conflicts, offered us a refreshing perspective. The reference of Lok Adalats and landmark matters like Ayodhya case illustrated mediation's power in even complex scenarios. You also shed light on role of conciliation in law, explaining how timely complaints can resolve many contempt cases, and how pre-litigation mediation can serve as a crucial gateway to access justice efficiently, reducing adversarial delays, sir. Your vision on ADR as more than legal procedure as a means to help parties reach satisfaction, rebuild trust, and move forward is inspiring, sir. On behalf of Vino Legal, our sincere thanks to you, sir, for elevating this session with your experience and wisdom. We also grateful to Dr. Purnima ma'am for her leadership in organizing this event and coordinating with you, sir. We are thankful for you both. Thank you very much, sir.
Thank you. Thank you very much. And I've mentioned my email in the chat box. There were one or two questions which I didn't answer. So if somebody would like to write to me privately, they are welcome to do that.
Definitely, sir.
Thank you. All the very best. Thank you.